Good morning, everybody. Thank you for being with us this morning. My name is Jim Howell, Chairman of the Sedgwick County Commission. Thank you for the audience for attending this morning. We have an interesting meeting planned today. Just really four major items, I think. It should be a much shorter meeting than last week. We have an appointment we're going to make this morning. We'll consider that, as well as an issue of agritourism, a bit of discussion on the annexation issue, and an amendment to our CIP. But thank you for being with us this morning. We are recording this. It's going to be available on YouTube as well as our county website later on. And we're being broadcast on KPTS Channel 8 live this morning. So thank you for being with us this beautiful October morning. And with that, Madam Clerk, first item, please.
Invocation to be led by Pastor Glenn Tombaugh, Mount Vernon Unit Methodist Church. Please remain standing for the flag.
Will you bow with me in prayer? Mediating God in these days leading up to another presidential election in our country, sometimes the political process seems anything but sensible and judicious, which is what politic actually means. Even though we vary, on our political views, our allegiances, help us today as Americans and help us in this county and this community to appreciate one another and to work together in a way that builds up rather than tearing others down. Guide this commission and their gathering today and all the visitors here in this place. May this deliberation be sensible and judicious as we keep in mind those whom we serve in this community. We thank you for the work that each one does this day and ask your blessing on all here today. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Pastor Tombaugh. Tombaugh, am I saying that correctly? Tombaugh?
I pronounce it Tombaugh.
Tombaugh. All right. Well, it's B-O-U-G-H at the end, so it's questionable. Anyway, Pastor Tombaugh, thank you for being here with us this morning for the prayer. And again, it wasn't clear to me, but he's pastor of the Mount Vernon United Methodist Church. So again, thank you for being here with us this morning. At this time, I will now call to order the regular business meeting of the Board of County Commissioners for the month of October the 12th, 2016. Madam Clerk, next item, please.
Roll call. Commissioner Unruh?
Present.
Commissioner Norton?
Present.
Commissioner Peterjohn?
Present.
Commissioner Ranzau?
Present.
Chairman Howell?
Present. All right, thank you. Next item, please.
Public information announcements.
Good morning, Commissioners. Kate Flavin, Public Information Officer. We have one announcement this morning for you, and so John Von Atchen with the Counselor's Office will be presenting some good news.
Good morning, Commissioners. As mentioned by Kate, John Von Atchen, Assistant County Counselor. We talked last legislative session about changes to the statute 75-7C20 that would allow individuals upon the adoption of a policy to apply for a way around our adequate security measures should they qualify, and I'm pleased to announce that we have a policy. I worked closely with the manager's office, with courthouse police department, specifically Chief Haynes and Ronald Spurgeon regarding the policy. We've had some input from the clerk's office, Kelly Arnold specifically, and we now have a policy, and it is online. So if you go to the main page on sedgwickcounty.org, on the left-hand side, if you scroll all the way down, you will see FastPass. And there are two parts to this. One is the policy, which is at the bottom, which you can click, and it will bring up the manager's policy regarding who is eligible and how to apply. And then if you go to the section directly under FastPass, you can click on the form portion of it, and then it will pull up a PDF of the application. Individuals who are interested and who can qualify for the FastPass can fill out the application, sign it, have it notarized, and return the application and pay downstairs at the pay station. We will review those, and then the individual will be notified whether or not their application has been accepted. If you are a member of the general public who will qualify for this, the fee is $25 if you do not have a concealed carry permit. If you do have a concealed carry permit, it will be $20. The policy does not allow for anybody to carry in the building, but it does allow them around the adequate security measures. We urge the public, the initial applicants, to be patient. In the policy, we have a 30-day window. If you have not heard from us within that 30-day window, we'd ask that you contact us. We expect a flood of applications initially, so please be patient while we review these. And then, if you have a business need to be in the building and you're here frequently, and you pass all of our checks, we'll be happy to have you come through our adequate security measures. Individuals who do qualify and are awarded a Fast Pass will get a badge. It will be the design is going to be green, so it will be very different from the county badges that we currently use. And individuals may go around in the main entrance. There's a pillar. There is a card reader. You put your card in the card reader. You show it to the person sitting at the X-ray machine. They make sure that the person that's holding the card is the actual person in the picture, and then they'll wave you through. So I expect that we will get a flood of applications, and we again encourage the public to be very patient with us. We will get to everybody.
That's great information, Mr. Von Atchen. There may be some questions or comments. Commissioners, any questions or comments for Mr. Von Atchen? Let me ask a question. I don't think, maybe you did say it, I'm not sure I caught it, but is this good for 1 year? Is it a calendar? How often do they have to do this application?
Once approved, it is good for 1 year. On the badge, it will actually have your expiration date. And so you will know in advance. You won't have to go look anywhere. You'll have it on your badge. And so you can say, oh, well, I'm a month out. I need to apply for a renewal, that following year.
And beyond that, there is an electronic reader that also reads the badge, so if it expires, it'll stop them.
What will happen is that once the expiration date has come to pass, the system will automatically not allow that pass to scan in as good. So what we're familiar with, the red light, green light system that we have, is that if an individual's pass has expired and they try to enter the building, it will give a red light and it will not allow them to pass.
Very good. Well, this is great information. Do we have any status regarding whether Wichita is implementing something like this at this time? Do we know?
The city of Wichita does have a policy. I checked. They don't have anything online. My understanding is you actually have to go into the building to get an application. I actually went over there and did that yesterday just to see what the process was like for them. But I think this will be a lot more convenient for citizens that want to apply. They can go online. There's a pull-down menu on the PDF. They can do it. They can fill in some of the areas that they need to fill in, print it, sign it, get it notarized, bring it in with your fee, and then we'll start the process of getting you approved.
Very good. Well, I have no other questions or comments. Commissioners, anything else? I see none. Well, thank you, Mr. Von Atchen, for the information this morning.
Thank you.
All right. Is there any other public information announcements this morning? All right, Madam Clerk, next item, please.
Public agenda.
Commissioners, I do have two people who've signed up to speak, but I believe they're intending to speak on agenda items that are coming up, and when they come up, if you want to wait until then, that's fine. I will certainly allow you to speak when the agenda item is presented, if that's acceptable. Okay? And is there anybody else that would like to speak at this time, generally to the commissioners? Okay. Seeing none, Madam Clerk, next item, please.
Appointments. Item A, resolution accepting the resignation of JAIME OEBERST, M.D., Sedgwick County District Coroner, and approving Timothy S. GORRILL, M.D., Ph.D., to serve as Sedgwick County District Coroner.
Mr. Chairman, Area K.S.A. County Councilor, agenda Number A is the appointment of Dr. Timothy GORRILL to serve as district coroner. Ms. Oberst had resigned some time ago, and this is a replacement for her. It's my understanding that he is present and to be sworn in. The paperwork appears to be in order, and I would urge adoption of the recommended action, which is to accept the resignation and approve the new appointment.
All right, thank you, Mr. Yost. I will at this time. Is there anybody in the audience who would like to speak on this agenda item? All right, seeing none, bringing it back to the commission. Commissioners, what's the will of the board?
Mr. Chairman, I move we take the recommended action.
Second.
We have a motion and a second to accept the resignation and approve the appointment. Any other discussion? Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh.
Aye.
Commissioner Norton.
Aye.
Commissioner Peterjohn.
Aye.
Commissioner Ranza.
Aye.
Chairman Howell.
Aye.
Good morning, Commissioners. I do solemnly swear that I will support the Constitution of the United States, the Constitution of the State of Kansas, and faithfully discharge the duties of the office of Sedgwick County District Coroner. So help me God.
I do.
Congratulations.
Thank you. Commissioners, I just want to say thank you for this opportunity.
Thank you.
Thank you.
You're very welcome. Congratulations for your new appointment.
Thanks.
All right. Before I go on, I do see that we have Mayor Goddard has arrived, and she's here in our audience. I want to recognize Mayor Marcia Gregory. Thank you for being here with us this morning. And with that, Madam Clerk, next item, please.
Planning Department. Item B. Amendments to certain sections of the Wichita-Sedgwick County Unified Zoning Code to permit event centers, churches, farmers markets, community assembly, and bed and breakfast uses by right subject to development standards in certain zoning districts.
Dale Miller, planning staff. As the commission is aware, staff was approached, seems like a long time ago now, but to review the Unified Zoning Code with respect to, was there a way to amend the code to allow agricultural producers to better utilize the buildings and grounds and facilities that they have on their agricultural properties? And so staff reviewed this, and the critical thing that came out of the review was that most of the people that we had discussions with were interested in the event center concept, where they could take a building that might be primarily used for agricultural uses, or maybe even be built just for entertainment or events, but be built out in the country on a farm ground, and that it be allowed as a use by right if they could meet certain development standards. So staff reviewed some ordinances and resolutions from other counties and cities, and we proposed what's before you today. Planning Commission did review this and recommended approval as you see it today. One of the things that came up as part of this is currently under the code, churches and other assembly type uses in the RR Rural Residential District are required to get a conditional use. Well, if the concept is to allow an event center, which is basically a community assembly activity, as a use by right, we didn't want to run afoul of the Religious Land Use and Institutionalized Persons Act, or RLUIPA is the acronym. And so we needed to take a look at how we treated churches and community assembly in the county and see what needed to be done to be consistent there, because essentially RLUIPA requires that you cannot be more restrictive on a church than you would a similar non-religious institution or activity. So what we ended up with is we have amended the definition of agriculture so that it's clear that products that are produced on site can be sold on site. We have moved churches or places of worship and a community assembly from a conditional use in the RR district to a use by right, provided that they comply with the 12 development standards that also apply to the event center in the county. We also moved bed and breakfast in to a use by right in the RR district because we'd had a number of requests for that in the county. And then we added farmers market in the county to make it clear that if you meet those development standards and you're on farm ground, that you could sell agricultural products that are not raised on site as a farmer's market. Now at Planning Commission, the original proposal was going to require some form of gravel or surfaced parking for these uses. The Planning Commission listened to one of the potential folks that want to run one of these businesses, and they wanted to be able to park on grass, and after a fairly lengthy discussion came up with a modification that is included in here, that if the event center is not used more than 100 days a year, then they would be able to use grass as a parking surface, provided that they provide a 50-foot long rock driveway. The concept being that if there is mud or dirt on the tires, that rock driveway would knock that off before it would hit the section line road. Again, as I mentioned, the Planning Commission approved this 8-0. There were 2 citizens that spoke in favor of the amendments and offered suggested changes. I believe there are at least 2 people here today that possibly are interested in speaking on this. Planning Commission recommended approval, and with that I'd try and answer questions.
All right. Well, thank you, Director Miller, for your presentation this morning. I'm going to go to Commissioners first. Commissioner Ranzo.
Well, I just want to say thanks for all the hard work you put into this. I know this has been an ongoing issue for a long time, and it actually was originally brought to my attention 2 years ago during the campaign with Senator McGinn. She was one of the people that was dealing with this issue, and there was another gentleman by the name of Dan Stockmar who has been involved with this as well. And along the way, I learned a lot about agritourism, and there is a state statute that is intended to encourage agritourism. That is the use of family farms to do things besides just the general agriculture, but to use it for other things that are still associated with agriculture, though. And so we wanted to make it as easy as possible for those little sorts of things that they might do on a daily basis and not really impact the surrounding area, to be able to do that by right, while at the same time addressing the activity center issue. And there was lots of issues to take into account there, and I know you put a lot of time and work and effort into it, and I think they're both happy with where in fact, I spoke to Senator McGinn this morning, and she can't be here, but she is supportive and thankful for all the efforts that staff put into this. And sometimes it takes a while to get these regulations and zoning codes changed and get everyone happy, but in the long run, I think it's good that we put the time and effort into it, and I truly do appreciate all the effort you and the staff put into it. So,
well, we're happy to have done it. Thank you.
All right. Further comments from Commissioner Peter John.
Thank you, Mr. Chairman. Mr. Miller, I want to also provide thanks to you and your staff, as well as to the folks on the Planning Commission who worked this, and also citizen input I've heard has been also positive, and I think that this is going to strengthen our local economy, give more opportunities to the folks who are in the agricultural part of Sedgwick County. And I think for a lot of folks out there, it's important for them to realize that even though Sedgwick County is the second most populous county in the state of Kansas, most of the land in Sedgwick County is ag land. And people, whether they're specifically on a farm or on a piece of property where they might be leasing it for farming or other purposes, agriculture is absolutely vital for this county, and having this provision in place, I think, is going to be a help for everyone in that part of the county. And I think it's also going to be a positive for the city folks who, I think it's very helpful when little kids get the opportunity to go out and see that milk comes from a cow, not from a grocery store. So this is going to be a positive step in the right direction. I'm happy to support it. And, I know there's been a lot of work to get us to this point today, and I wanted to recognize that this morning. Thank you.
Well, I'd like to go ahead and go to the public at this point and ask, is there anybody in the audience that would like to speak on this agenda item? All right, seeing none, bringing it back to the board. And my only other comments from Commissioner Ranzo. Go ahead.
Mr. Chairman, I was just going to move that we adopt the findings of the Metropolitan Area Planning Commission, approve the proposed amendments to the Wichita-Sedgwick County Unified Zoning Code as recommended by the MAPC, and approve the resolution.
Good.
Second.
We have a motion and a second. Excuse me. My only other comment is, this was recommended by MAPC on a vote of 8-0, which I appreciate the work that they've done as well. State law does allow for this type of activity, it even encourages it, I would say, as I've read it. To me, this is one of those things where it creates new opportunities in the community. People, sometimes I hear people say that they can't. There's not things to do in the community. There's things they would like to go do, but they're not things to do that they can think of. Well, there's going to be all kinds of new ideas develop around this opportunity. Everything from pumpkin patches to corn mazes to haunted houses to, as Commissioner Peter John, children learning education opportunities of children at farms and seeing how food is made. There's just a tremendous opportunity, I think, for us to allow a little bit of freedom on this issue and let people use their land to find ways to provide new opportunities and maybe make a little bit of money on the side. So to me, this is a great opportunity, and I would like to support it as well. Any other comments from commissioners before we vote? All right, we have a motion and a second. And with that, Madam Clerk, please call the vote.
Commissioner Unruh?
Aye.
Commissioner Norton?
Aye.
Commissioner Peter John?
Aye.
Commissioner Ranzo?
Aye.
Chairman Howell?
Aye. Thank you, everyone. Next item, please.
New business. Item C, consideration of lifting of restrictions contained in restrictive covenant and journal entry for property at 6,609 North Woodlawn.
Morning, Commissioners. Justin Wagoner, Assistant County Counselor, here to present on property at 6609 North Woodlawn. It's currently owned by a company named Boop LLC. They've submitted a request to lift some restrictions on that property that were a result of some litigation that occurred in the late 1990s between Sedgwick County and a prior property owner, a prior owner of that property. I'm going to start out with a brief number of maps to kind of give you some background as to the property and the surrounding area, and then after all that I'll kind of get into some of the historical background on this property to further explain the request that's been made. Well, this first map here is showing the property indicated in red, and it's a 44-acre piece of property in the unincorporated area of Sedgwick County to the north of the city of Keachai. If you look at the city of Keachai, I think it's more or less northeast of kind of the core of the city of Keachai. The second map on here is an aerial of the property. It's zoomed in a little bit more. It's from 2014, I believe, that just kind of shows what it looks like from above. You'll note that on the west side of the property is a railroad. On the east side of the property it's stated as 63rd Street, but essentially that is it's Woodlawn is to the east of this property, I should say. And it's unpaved on that portion of Woodlawn. Also, both to the north and south of this properties are rural residential properties in the unincorporated area as well. The next slide on here shows zoning for the property. The roughly western half, it's about 25 of the 44 acres, is zoned as rural residential, and then the other 19 acres on the eastern half is zoned limited industrial. Also to point out that there are some commercial buildings on the eastern half of the property and some other, I think, commercial infrastructure. On the western half, there is a cell tower. There's not a residence on this property, despite it being zoned rural residential. The next map on here shows, again, the property outlined in red, and then it shows the urban area of influence for the city of Keachai. This property is within the city of Keachai's urban area of influence under our zoning code. What that means, and I think you all are pretty familiar with this, but is if there were to be a zone change or any action like that on this property, it does have to, prior to going to the Metropolitan Area Planning Commission, it actually goes to the Keachai Planning Commission for a recommendation. The matter that's in front of you today is not a zone change, just to be clear. It's a whole entirely separate matter, but it does, of course, affect the property. And then the last map that I've got on here is a map that shows, again, the property outlined in red, and then it shows the zoning for the unincorporated area and also the zoning for the city of Keachai. What you'll note is, again, the property has two types of zoning on it. All of the property that surrounds it in the unincorporated area is zoned rural residential. However, the city of Keachai has a kind of a mixture of uses. depending on what direction you go from the property. And it may be a little small to see some of the scale, but things I would point out, this property is somewhat at the confluence of three different types of uses. If you go to the west of the property, there's some subdivisions in the city of K.S.A. Again, around it, it's rural residential. And then if you go to the southeast of the property, that pink color is industrial zoning within the city of K.S.A. So there is a fair amount of industrial zoning in the vicinity as well. Now, moving on to some of the history on this property. In the late 1990s, there was a prior property owner, Maurice Castor, who operated a company called Castor Excavating. It was a recycling business. Some of the activities that he undertook on the property that were contrary to how the property was zoned, were uses that were not allowed. He, in short, was dumping construction debris on the property, and he operated a metal recycling business, and some of the stuff he was doing was not allowed, again, with how the property was zoned. So at that point in time, the Sedgwick County's code enforcement director had written a notice of code violation to Castor Excavating. They challenged that letter to essentially that opinion that had been reached in it to the Board of Zoning Appeals for Sedgwick County. Board of Zoning Appeals ruled in favor of the county's position on the matter. Castor Excavating then exercised their rights to appeal to the district court. When this matter got to the district court, ultimately the parties reached a settlement agreement under which there were restrictions put in place on the property as a result, and those essentially manifested themselves in two different places. First, there was a restrictive covenant that ended up eventually being recorded with the Register of Deeds. And then secondly, there was a journal entry that was filed with the district court. Both of those had a number of listing of restrictions on the property. The request that Boop LLC, the current owner, has made is to lift all of those restrictions that are currently in place. Just briefly, the restrictive covenant is valid until 2024. It was for 25 years, and it began in 1999. It does run with the land, meaning that it applies to future property owners. The current property owners, again, were not the owners back in the 1990s during the litigation, but the conditions of the restrictive covenant apply to this day. Both the restrictive covenant and journal entry define RR property and LI property based on the LI, meaning limited industrial zoning portion of the property that I showed to you earlier on the map, and the RR based on the rural residential portion. The restrictive covenant lists a number of activities that are not permitted on the property. A number of things such as storage of scrap metal, above ground storage tanks, excavation uses, a whole laundry listing of uses they didn't want to allow on the property. I think the aim was generally, these were activities that Castor Excavating had been undertaking. The aim was not to allow some of those uses because they were maybe contrary to what should have been allowed on the property. Again, this document, like I said, is of record. Because of that being filed with the Register of Deeds, it would have been on record for any future property owners to see that if they had done, doing a title search or anything along those lines. The restrictive covenant does not identify any third-party beneficiaries, meaning it specifically says there are no third-party beneficiaries. So even though there were neighbors who complained on the code enforcement matter, they are not technically beneficiaries of the terms of that restrictive covenant. The county is the benefited party under that, the terms of the restrictive covenant. And lastly, it says that it can be amended at any point in time by a majority vote of the county commissioners in agreement of the property owner, and that includes any future property owners. The journal entry has very similar restrictions on use, and it does limits things that are limited in the restrictive covenant more or less. There is one thing I guess I did want to point out about the restrictive covenant as well is that beginning in either 2010 or the transfer of the property to a non-lineal descendant of the Castors, both of which have occurred because Boop LLC is not a lineal descendant of them, and then secondly, of course, we're past 2010, even the LI zone portion of the property can only be used for rural residential purposes. So there are not an especially large number of uses that this property can be put to. In the backup materials, there's a document that shows it's got 3 different columns, and it shows the number of uses that are allowed for the rural residential portion of the the left column of that shows the uses that are currently allowed, which there's only a handful of those. The other 2 columns show all the uses that would be allowed if the LI zone property were treated as it's zoned. And then to explain the history on this, Mr. Castor had passed away in 2008. In 2009, the property was sold to a John Bourne. Mr. Bourne and his family, as I understand it, own Boop LLC. Mr. Bourne had passed away in 2011, but both his wife and son are here today, and again, their company owns the property. It's been operating as Stone Masons Incorporated, and it continues to be used by that business. They've indicated an intent to sell the property, make it more marketable by lifting some of these restrictions. There's a little bit of a history in that this property had previously been proposed to be sold to a company that was going to operate an asphalt plant on it. That drew a lot of neighbor opposition when this went to the City of Keachai's Planning Commission. The City of Keachai's Planning Commission actually recommended against the use, and ultimately the sale to that potential buyer fell through, I think in part because of the concern that the neighbors were against it and that maybe the conditional use that was proposed would not be approved. A few months later, another company was interested in relocating there. The use on that property, or the potential purpose, it was an HVAC company. That fell through for different reasons, but essentially this portion of Woodlawn is not paved alongside this property, and they were going to build some buildings on there, and doing that would trigger some of the road paving requirements and the subdivision regulations. So at this point in time, I think the property owners really just wanted to be able to see if they get these restrictions lifted so that the property would be more marketable and they can make an economical use of it. No notice is required on this matter that's in front of you today, but to be transparent, to be welcoming of feedback from many of the surrounding property owners, we did send out a notice about today's hearing to all the property owners in the area that would align with a zone change, and we did it similar to a statutory notice for a zone change. The recommended action on this matter is to grant the request that's been made by the property owner to lift the restrictions on the property, and to authorize the county counselor's office to take action to remove those restrictions contained in the restrictive covenant, the journal entry. The reasons for that is we think that the restrictions put in place in the 1990s were a little bit of overkill, perhaps. In hindsight, I think based on a prior bad actor on the property. A second would be to allow them to make some economical use of the property. And then lastly, it would really put it back to how the property is zoned, which there could be a common sense reason for that. Alternatives to that would be to take no action, leave the restrictions in place, or another option that I think could be a reasonable alternative would be to lift some of the restrictions, but not necessarily all of the restrictions. And that's something that, again, the document in your backup material should show the uses that are currently allowed, all the uses that would be allowed by LI zoning. And if you would, you could take a vote on maybe things that you would think would not be appropriate for the property. I believe that the current property owner, their council, have talked some with the neighbors, and they may be able to elaborate on what they think is or is not appropriate on as well. At this point, I'd also say that Dale Miller's here, the planning director. If you have any questions on any of the zoning issues or on this property, a simple majority vote is what would be required to take action. I'd be happy to stand for any questions that you might have on this, and lacking any questions, I would defer to any other input.
All right. Well, thank you, Mr. Wagner, for the presentation this morning. Commissioners, any initial questions or comments as we get started this morning? All right. Seeing none, I'd like to go out to the audience here in the public and ask them, is there anybody here that would like to speak on the agenda item? I do believe I have Patrick Matson here. I'd like to call up Patrick Matson. Please state your name and address for the record, and thank you for being here this morning.
Good morning. I'm Patrick Matson, 7101 East 69th. My wife and I have owned the farm just due east across the road from the property. It's a century farm, so I'm very familiar with the area all my life. I'll be brief. I have 5 points why we should keep these covenants in place. The covenants were an agreement between the landowner and the county at the time to protect the adjacent residential property owners when they were established. Second, county went to great expense, hired outside attorneys, and the restrictive covenants were the agreed upon result to protect the rural residential surrounding property. 3, now that it's inconvenient for the current owners, they should just not be thrown out. maybe something in between can be done. Throwing out the covenants would be more or less a blank check. You know, I always thought typically in the zoning cases we had some known use, some known proposal of use when the restrictions were loosened, and that doesn't seem to be the case here. Lastly, I'd like to remind the Commission that it is surrounded by rural residential or R4 homes and less than 1,000 feet away from the property. And that's all I have. I would recommend not doing anything at this time, but any questions?
Commissioner Ranzau.
Yeah, can you clarify for me, what land do you own? Just east of there, across the
directly
street?
east, across the road, east of Woodlawn.
And how much? Is it a quarter section or?
Yeah, it's a short quarter, 144 acres.
So, okay. But to the south of you, you have area that's zoned industrial already.
Yeah, there's a nice buffer there, and here again, that use is probably okay with being adjacent to residential. Here again, you know, we're just concerned about the future usage of this particular property. We've got the scars to, you know, past scars to remind us that, you know, we need to be careful here. That.
And I guess I'm a little confused because maybe I'm mistaken. But the property in question is going to have limited industrial, just like the one to the south. So you would have the same uses in the south. I mean, or is that wrong?
Well,
I might be a little confused.
Go ahead.
And I'm sorry, when you say the property to the south, the property to the south of what?
South of his land already is limited industrial.
It's industrial. It's K.S.A.'s industrial property. I don't know I'm not familiar with their zoning code. I would imagine some of the uses are similar. And Dale Miller might know more about that. But yeah, I mean, it's zoned industrial. I believe the term is, trying to see how they've termed it, industrial district. They also have a light commercial district and a heavy commercial district. Industrial appears to be the most intensive use that they have, according to the chart on the right of that.
Okay. Do you have any way to compare what theirs is compared to ours? You're saying their industrial is the most intense that they can have there.
And I'm just solely going based off of what's on this key, but I believe that's correct.
Okay.
Commissioner Ranzau, there's agricultural use, single-family residence, multi-family residence, and then it says special commercial, light commercial, heavy commercial, and then industrial. I would think industrial would be the most intensive of those uses.
Of all those. Okay. Thank you.
I would like to point out the time that was rezoned, that was a known use. A company was going to move in there. It was very known. In this case, this property is for sale, so we really don't know what that usage will be in the future. It may or may not be acceptable to the surrounding rural residential type zoning.
Okay. Thank you.
Thank you.
We have, please hang on. Commissioner Peterjohn, please, has a.
Thank you, Mr. Chairman. Mr. Madsen, I want to make sure and get this clear for the record, since you said you've got kind of a short quarter section. Does your property actually abut this area that's inside the city limits of K.S.A. From this map?
Yes.
I can't tell.
It joins the pink area on the map on the south. So my property does touch the southern industrial.
It does touch it.
Yes.
Do you know when the city of K.S.A. went ahead and did that industrial zoning? Because you said there was a company that was planning to go in, and I guess they didn't.
Yeah, it's under construction currently.
It's under construction currently,
yes.
So there is somebody going in there.
Yes.
At the moment. Okay.
It was about 4 years ago, I believe, when they changed that zoning, as best as I recall.
Okay, because and you've owned this property. Your
since 1995, my family has owned it since the 1880s.
Okay. Thank you.
Thank you.
All right. No other questions. Thank you, Mr. Madsen. Frank Dugan?
Yes, sir.
Did you want to speak on this agenda item?
Yes, sir.
Thank you.
Yeah, a little bit of the same issues. I might like to elaborate on them a little bit more. The covenants that were placed on this land were for good reason. They weren't arbitrarily applied to it. We don't have any objection to a company conducting business in our vicinity outside of the ramifications it might have for property owners, which we have a history with already on this property. I've been on my property for just short of 30 years. I am located directly across the street from it. My property also touches the pink large area right there. And let me elaborate a little bit on this. When K.S.A. Excavation owned the property, he conducted the excavation business for many years, got along with the neighbors very well. But at one point in time, he expanded it to a metal crushing operation. He put in what was basically a hammer mill. It created pollution. It was contaminating the land that was adjacent to his property. It had excessive noise. It exceeded limitations by the county. The area residents had to hire lawyers, put a great deal of effort into getting this operation under control and finally shut down. That was the reason for putting in the covenants. Now, the area is surrounded on all four sides by residences. So there is not a good buffer for a heavier industrial application such as was with K.S.A. and the residents that were there. As things progressed, we have absolutely no disagreement with the operation that's going on with the stonemasons that currently operate it. I think they're very good neighbors. However, they also demonstrated a lack of concern for the resident areas when they tried to sell the operation or the property for an operation that would run asphalt. An asphalt operation would have polluted the air severely. People that live near an asphalt plant suffer from lung diseases. It puts oil into the air, you breathe the air. We again had to unite as residents in the area. We had to take legal counsel. We had to go to meetings. We put a great deal of effort into stopping this. And this was just this summer. This was not a long time ago. And so we are very concerned that, that any operation that may be coming in might work within the LI, but might be incompatible with the residents that are already directly adjacent to this property. We would like to see a certain amount of control left in place so that we can have a good relationship with whoever might come into this property. And for that reason, we believe these covenants should be retained. They were put in there for good reason, and the events of this summer showed that there is still a good reason they should not be discarded. And so in light of that, we recommend that the covenants be left in place, that this effort be tabled until such information can come forth on the type of business that might be coming in. And if it's a business that is compatible with residents in the general area, we would have no objection to that. But right now, that information is not available. And the current owners have demonstrated that they're not going to filter out anything like that. They had no objection to putting in an asphalt plant, which would have rendered our property unlivable and unsellable. So that is the concerns that we have in this area. Any questions?
Well, thank you, Mr. Dungan. Am I saying your name correctly?
Yes.
Dungan. Thank you, Mr. Dungan, for your comments. Commissioners, any questions or comments from Mr. Dungan? All right. I do have one question. That is, have you looked at the have you looked at this list of current use versus LI uses and then conditional use topic? I guess I should say business activities that would be under conditional use. Have you looked at this list?
Yes, sir. In fact, excuse me a minute. In fact, I was on the Zoning and Planning Commission for a number of years in K.S.A. as well.
Okay. Has K.S.A, as a city, I'm not sure I heard it earlier. I mean, I apologize for not hearing it if it was presented, but has K.S.A weighed in on simply lifting this restriction? Okay, they've not weighed in yet. Okay. All right. And if I understand correctly, on this list of items, is there anything on this list that you would, I mean, have you guys considered filtering this list in any way, saying these are things we would think are reasonably acceptable and these are things we don't want to see?
Excuse me just a moment. My throat's a little dry, sorry. We would entertain discussing it with the property owners and maybe their council, but we would like to reserve the ability to restrict anything that would be objectionable and detrimental to our property. It's really quite simple.
Commissioner Peter John.
Yes, thank you. Let me ask a couple of questions. One of the options, actually, we have a variety of options that we can take here as a commission. I'd like to get your input on some of them, see what you think, and if Mr. Madsen wants to jump in too, I'd be happy to hear his comments. One of the options we have is to take an action on the restrictive covenant, but not on the journal entry, or we take an action on the journal entry but not on the restrictive covenant, which expires in 2024. Since you've been on the Planning Commission, have a little bit more knowledge of how that goes and are very familiar with this property, do you have any thoughts on those two ideas and have a position on either of those two options for us this morning?
Well, as I said, I think it would be best to table this option at the moment until more information can come forth. We wouldn't object to having some discussions on this and just getting some type of assurance that there isn't going to be something in the neighborhood of, say, an asphalt plant that would be moved in next to us.
Well, let me ask you then, if we had a restriction in place that it could not be used for an asphalt plant, but it would have we would eliminate some of the restrictions that are currently in place as part of this covenant and the journal entry. Is that something, what would your position be on that?
Well, we can't anticipate all businesses that might come in there. LI is a very broad opening for businesses that may come in there. We simply can't have any foreknowledge of what might come in. So it may not be an asphalt plant, but it could be other items that are very objectionable. You could have excessive noise from many operations. You could have excessive truck traffic, for instance, on the road, might be objectionable to it. They might, say, generate debris that would blow off the property. We just don't know what type of operation might come in. And we feel that the LI zoning is too broad for the conditions that are in this area.
Well, let me ask you, I'm looking at the sheet that you filled out that had your address on it, and that you're south of Mr. Madsen's property.
I am just, for the most part, east. I'm right on Woodlawn. I have 10 acres across the street from the subject.
West side of Woodlawn?
I am on the east side of Woodlawn.
Okay, and you're south of, so you're south of Mr. Madsen's property, is that correct?
Correct, yep.
Okay. That's all I have at this point. Thank you, Mr. Chairman.
All right, thank you, Commissioner Peter John. Thank you, Mr. Duncan, for your comments as well. Anybody else from the audience that would like to speak on this agenda item before we move on? All right, last call. Yes, sir.
I'd like to just speak on behalf of the landowner.
Yes, please come to the podium, state your name and address for the record. Thank you.
Good morning, Commissioners. My name is Robert Smith. I'm an attorney at Folston Siefkin, and I'm joined today by Betty Bourne, her son Mitch, and his wife, Epek. there was a couple of just points that I wanted to address. One of them is we had asked that these restrictive covenants be lifted, not only for the reason of future sale. It would, of course, be beneficial if these were gone before we sell it in the future. Sell is not certain. It's something that has been entertained, but these restrictive covenants actually impair their ability to continue operating their existing business there, where they're currently operating and employing around 60 employees there. As the neighbors have said, there's not been any objections to their current use, but unfortunately, the Bournes didn't know that these restrictive covenants were there until recently. They were of record, and maybe we should have known, but they weren't. Didn't know, and the restrictive covenants are so restrictive. If you look at the list of uses, it actually would prohibit their current use of the property that they're making of it. So we have more reason than just a future sale. This is actually an immediate concern for them. The kind of second point or question that I had is we actually had listened to some of the input from the neighbors and have had some discussions with some of them. One of the things that we had, and even before we started this most recent process, we had talked to, back during the issue with the asphalt plant, we had talked to, I believe it was Bob Harnicott was here and was originally assisting with that before Justin jumped on board. We had talked to him about, maybe one of the things that we could do as part of that rezoning is, whenever we go and rezone in the future, agree to some reasonable use limitations on use. So we actually came up with a list that we had worked with. I think the county staff had an ability at the time to pitch in. This is not a formal list. This is kind of an informal process, but we came up with a list that we thought worked for us and that the county thought was a reasonable list. So I've got that here. Would be happy to give you guys a copy of that. We had distributed it to all of the landowners, neighboring landowners that had approached the county and had asked and got in contact with us. And one of the things that's on there, of course, that we struck through would be asphalt plant. So we have tried to make some reasonable accommodations on that front to address some of those concerns.
May we see the list?
Yeah, would be happy to. I've got, let's see, there's 5 copies. And I've got a couple of extra copies for if anyone else would like to see that. Sure. I guess probably the final point, or a couple of points here, is these restrictive covenants were put in place. Prior landowner, we're not doing the same things they did. They've not aged well if you go through and look at them, and a lot of them are very specific and focused on the caster's use at the time, and are really directed towards that landowner. Like the landowner can't do X unless it's related to their existing use of, and so a lot of the restrictions that are in place have effectively aged out and are no longer applicable. Definitely not to our current uses and wouldn't be to anyone in the future. But what they do have the effect of doing is prohibiting this future people from even doing the things that the prior landowner could do. And these were also put in place the year before the nuisance code was put in place for Sedgwick County. So a lot of the items that are in there are actually now addressed in the nuisance code regarding the neighbors' concerns on the scrap metal and things like that. And I have a copy of the nuisance code as well, but here, if you guys would like to see that. But a lot of those concerns are now addressed in the county's ordinances. So I think that's, unless you guys have any questions, I think that's...
Well, there may be some questions or comments. Commissioner Unruh?
Thank you, Mr. Chairman. See, Mr. Smith, right?
Yes.
The current activities on the property, as I've understood the testimony, is not in compliance with the current restrictions.
That is correct. We did not know of the restrictions until they were brought to our attention.
And it's a rock cutting business or something?
Mitch, do you guys want to talk to that? Because I could tell you guys, but I'd be wrong.
We own a masonry contracting business. We do mostly commercial work, some upper end residential, brick, block, and stone.
And how long has that activity been going on?
Well, since we purchased the property 18 months before my husband died.
Okay, thank you.
Mm-hmm. We've owned the company much longer than that, but we moved to that location then. Mm-hmm.
All right, thank you.
So that was back in 2009 that they've been there operating there since.
Okay. Now, the list that you gave us with the lined through activities, you're saying to us that you would be agreeable to restrict those going forward in our action today.
Correct.
And that includes restricted against asphalt plant and a nightclub, sexually oriented businesses, correctional facilities, and some of those things. And you would be agreeable to that?
Yes, that was the list that was presented to us. Like I said, it was an informal list by Bob. But yes, we've gone through that list, and we are agreeable to eliminating all of those uses.
Okay, thank you. I think that's a real effort towards compromise, so thank you. That's all I had at this time.
All right, thank you, Commissioner Unruh. Any other comments from commissioners? All right, see, Commissioner Norton.
Well, as I looked at the list that we have here of current uses and LI uses, I went through and dotted the ones that I thought would be very controversial, that over the years, that if those uses came up in a place that had neighbors and people close, would be controversial, there'd be protest, and we'd have to go through a long, arduous process. And it's amazing that it's exactly what you'd highlighted in your thing. I'm pretty well okay with moving forward with lifting some restrictions, but obviously there are some points here that are going to be controversial, that are going to need to be weighed in with the Planning Commission at K.S.A. and Metropolitan Area Planning, if we would move forward with total unrestriction. And I don't know if we're ready to do those compromise kinds of things today, but I think that makes good sense that we lift some restrictions to let the property owner at least market and try to move forward with the sale, but not be intrusive with items that are obviously going to maybe be controversial, not liked by the neighbors, that would create protest, and that gives them a chance to get started on marketing, but it also assures the neighbors that there's not going to be the extreme uses, it would be maybe the lesser uses that would happen. So I think as a commission we need to have some kind of a conversation about that, because going from the very limited uses to the very, very expanded uses, I can guarantee you will create controversy as they try to zone it and take it through the process. And if we can eliminate some of those right now, I think it would benefit both parties.
Well, very good. Very good. Thank you, Commissioner Norton. Any other questions or comments for Mr. Smith? All right, seeing none. Thank you, Mr. Smith, for your comments this morning. I am curious whether or not Mr. Mattson or Mr. Duncan have actually reviewed this list that was provided by Mr. Smith, and if you had any comments regarding that list.
No, sir, I have not seen the list.
Please come to the podium and just let me know what you just said. That's fine.
No, sir, I have not seen that list.
You've not seen the list?
No.
All right. We could go ahead and provide a list for you both to review real quickly, and then I'll give you a chance to come up in just a moment if that's okay. Commissioner Unruh?
Thank you, Mr. Chairman. Justin, could you help me review some things here?
Yes.
This highly restrictive uses on the property, just to reemphasize, were initiated because there was a very bad actor.
That's correct.
And so in order to solve that problem, these very tight restrictions were imposed. And
That's correct.
Journal entry was made. but it was still had been previously zoned LI.
That is also correct.
Okay, so I guess my point is that these tight restrictions were not so much with the land use, but with the individual who was acting out of bounds.
That's correct, Commissioner Unruh. I think there's some truth to that. I think it was based on his use. Some of the intent, from what I could tell, and again, I didn't work on the matter back in the 90s. I hadn't quite passed the bar yet. But the intent was to be able to readily stop him or pretty much enjoin his illegal activities on the property. And there was some intent to have that carry forward. And, of course, the restrictive covenant runs with the land until 2024. Our office's opinion has been that the journal entry also does run with the land. I believe that the Property Owners Council may have a slightly different take on that. However, I think that, and to your question, the uses he was doing were contrary to zoning. As Mr. Smith pointed out, they would be contrary to the nuisance code that would apply to the property. There would be means to address if a subsequent property owner did those types of things to address those. But you're right, there are uses of the property that I think that some of the neighbors have obviously identified they find objectionable. And those are uses that, but for C.A.S.A. Excavating having all those issues, this property would still be able to use all those today. The only reason they can't is because the litigation from the 1990s.
All right, thank you. Another question is it required that the property revert to RR zoning should these restrictions be lifted?
It's not required to revert to RR zoning. It's currently, as Mr. Smith pointed out, it can own the whole entirety of the property, even the LI zone portion, can only be used for RR purposes. However, at any point in time, the restrictive covenant can be modified by a majority vote of the commissioners and also the property owner. So it doesn't require it to revert to RR specifically, but to this point it has, as a matter of we're past 2010 and the property is transferred to a non-lineal descendant. So,
well, there is an understanding by some of the property owners that are neighbors that were required by law that if there should be any change made, it should go back to rural residential zoning, and that is if we don't do anything, I guess it has to. But
if you didn't do anything, the county councilor's opinion is that the restrictions that are in place limits it to RR zoning. Specific as a result of what occurred in the 1990s, not as a result of any statute or anything like that, but just as a result of the restrictive covenant that runs through 2024 and the journal entry that applies indefinitely.
And as a general statement, those were imposed because of someone who was acting beyond the zoning requirement.
That's correct. And there's some indication in the pleadings that he was a little defiant after the Board of Zoning Appeals intended to continue his use of the property. I think that's part of the reason. I mentioned it as being overkill. In fairness to some of the neighbors here, in context, in the 1990s, that may have not been overkill. I think, nearly 20 years later, perhaps it is. Also, it's a little bit atypical for the county to be in the position of holding a restrictive covenant. I mean, we have a zoning code in place that would still apply to this property. If, for example, an asphalt plant were to come in there, they'd have to do a conditional use like was done late last year, early this year for the asphalt plant that was ultimately withdrawn. And so there are protections in place for some of those property owners, both whether it's with the county code, the nuisance code, things like that, or the zoning code.
Okay, I think for right now that's all I have.
I thank you, Commissioner Unruh. Other comments, Commissioner Norton?
I guess I'd be interested in some comments with K.S.A. as they move and have a zone of influence, growth, a plan as to where this fits in. I see Bob Conger here, who's the city administrator, and I don't know that makes a difference, but if it has to go through their zoning area of influence and they have to weigh in on it, if it mucks up something with the growth plan, then I think we need to know that on the front end.
I'd like to invite you to say whatever you'd like to say this morning. Just give us your name and your title, and that'd be fine.
Thank you, Mr. Chairman. Robert Conger. I'm the city administrator of the city of K.S.A. The property in question is one of concern to K.S.A. as one of the neighbors, and of course this falls within the urban area of influence within the city's purview. We share similar concerns of our rural neighbors of how these properties are used. At this point, the city is currently satisfied with the notification process of the county councilor and the planning and zoning departments as they have executed these things in the past. There's been adequate notification, and we feel that at this point, with those notifications and the current procedures in process, that we have no objection with moving forward with things the way they are. That being said, again, we're very well aware and concerned about the welfare and benefit of those residents of Keachai with regards to their properties, with their quality of life and their property values. And so we will stand by those and uphold the welfare and the best interests of the citizens of Keachai.
All right. Thank you, Mr. Conger. Any other questions or comments from Mr. Conger? Commissioner Norton, was that satisfying?
No, I just thought that since Bob was here, that we made sure that, and it's going to fall in that zoning area of influence, that we kind of knew what their growth plans were, where it fit in with their conversation, and I believe any zoning changes would eventually go through their planning commission. So I think we need to make sure that's on the record.
Mr. Chairman, if I could address Commissioner Norton's comments. This area is in Keachai's growth area and plans for growth. We are not very aggressive as a city at this point of actively going out and promoting and pushing annexation into certain areas with any desire of affecting influence. We, as a city, are more concerned about natural and organic growth. We prefer to let that occur as it may, and the property owners, if they are approached by people to purchase their land and change zoning, we would prefer that occur more naturally rather than being imposed.
And Mr. Conger, do you know, it mentioned there's about 60 employees at this plant. Do you know if, is there a number of them that live in the city of Keachai, do you know?
I'm sorry, which plant?
Well, there's about 60 employees, they said, that's in the current facility that's running a business there currently. Of these 60 employees, do a number of them live in the city of Keachai?
I'm not aware of how many actually live in Keachai, but I will say that since the property has changed hands, the Bourne family have been very good neighbors, and we have no reason to take issue with any of their activities at this time.
All right, well, thank you, Mr. Conger. I'm not sure there's questions for you right now, but if there is, we'll ask you to come back up. But I'll go to Commissioner Peterjohn next.
Well, thank you, Mr. Chairman. If I can ask a question, Mr. Conger, and maybe this is part of the scalability and challenges with this map. We've been told that you all have industrial zoning in that area on the east side of Woodlawn, north of 254.
Yes, sir.
And the last time I drove in that general vicinity, and that's in Commissioner Unruh's district, it's a bit of a piece from mine, but I did try and check out when the asphalt plant was a bit of a controversy. Woodlawn was unpaved north of 254.
Correct.
From looking at this map, it looks like you've got a stretch where you've got industrial zoning on the east side of Woodlawn north of 254. It's kind of hard for me in terms of exactly how far that stretches up and if there is a plant going in there at this point. Can you kind of give me the status of where the city's plans are in terms of the road there? And you're a third-class city, I believe, so
yes, sir.
That would be a connecting link road, and that would still be under the county's purview. But I wanted to get your input in terms of the road situation in light of your development plans within the city of Keachai that's close to this property.
Yes, sir. The property, the westernmost property in pink, sort of the reversed L-shaped property is owned wholly by one property owner who is developing the property for industrial uses. All of his activities are going to be enclosed, not outside, no particularly heavy industrial activities being conducted in the outdoors. There is a short stretch of woodlawn that will need to be extended further north to attach to an unyet constructed street by the name of Tigwa Street. That street is being designed at this point in time by engineers, which will extend through that property and connect to the adjoining section over in front of the Highway Patrol building to the far eastern portion and beyond the eastern portion of this property. All of those activities are being funded through grants through the city of Keach-I by the Kansas Department of Transportation, and so we are working with KDOT and getting these properties improved to allow access to Woodlawn. All of the stretch of Woodlawn will be paved up to that portion in order to be able to handle heavier industrial traffic.
How big a stretch of Woodlawn will be paved once they do that?
It will be paved up to the corner of where the pink industrial portion of the property abuts Woodlawn on the northern portion.
Okay. Thank you very much.
Thank you, Commissioner Peter John. Commissioner Ranzau.
I actually have questions for Justin. So.
Okay.
Thank you very much.
Yes. So clarify for me. I think you said this a couple times, and I'm reading this here that this covenant that was passed by the county lasts for 25 years. That means, does it expire in?
That's correct. In 2024, it expires.
And at what point? At that point, then all these restrictions go away?
The county counselor's office's opinion is no, because there's a journal entry that has a listing of restrictions. There's some case law in Kansas that talks about injunctive actions, how those can run with the land unless a court subsequently modifies them. So our take on it has been that there are still restrictions in the journal entry. That's why the proposed action includes lifting the restrictions in both. I know Ms. Bourne's counsel, the property owner's counsel, has taken a different tack on that. I think there's probably some case law perhaps that's in favor of that position as well. So I don't think it's as settled as an issue. But clearly the restrictive covenant ends in 2024.
The restrictive covenant?
Correct.
Meaning the resolution that we signed, or the county signed.
Well, the county did two things. The outside counsel is representing the county commissioners at the time did two things. They did both the journal entry and the restrictive covenant, and the journal entry also incorporates the restrictive covenant in its terms as well.
Okay, so half of it you would say certainly does go away, the restricted covenant.
That's
the question is whether or not the journal entry would remain or not.
Correct.
But it's clear to me the intent here was for it to last for 25 years. It seems, anyway.
That's a reasonable position to take. I don't think it's unreasonable, but and I think that's the position Mr. Smith would take for his client, is that the terms of the journal entry were specific to that property owner. And the cleanest thing would probably be to handle both of them, regardless of what action you take, or not handle them if you choose to take no action.
Okay.
Thanks.
All right. Thank you, Commissioner Ranzau. I have actually asked, is there anybody else in the audience that wanted to speak on the agenda item? All right.
And Commissioner Howell, there are a couple of extra points I wanted to clarify, if I could.
Go ahead and clarify those items. Right
Okay, just very quickly. The first is that, to Commissioner Norton's question about running this by the City of Keach-I's Planning Commission or the Planning Commission, the Metropolitan Area Planning Commission, there's no requirement to do that in this case because this isn't actually a zone change. It operates functionally in some ways similar to a zone change, but it doesn't actually have to go to them. But there's also no reason the County Commission, if it wanted to, couldn't refer it to them for kind of an opinion, an informal opinion on it. The second thing would be, I think there was some comment about if it's required to have some sort of knowledge of what's going in there. And the answer is there is no requirement in front of you today to know what's in there. Also, in our zoning code, we often have zone changes where they don't know the use that's going to go there yet. And so this isn't unique, I guess, amongst, if you're comparing zone to zone cases where we don't know what the use might be in the future. That's all.
Thank you for those clarifications. And so, again, going to the audience probably as a final time. Is anybody else in the audience who would like to speak on the agenda item? Please come on up to the podium and state your name and address for the record. Thank you.
Good morning. My name is Joe Choi. My wife and I, we reside at 6301 North Woodlawn. And we just have a little over 5 acres there, just about quarter mile south of the red property in question. I guess the only point I would like to make is, the court order called for it to revert back to rural residential. And just because it did not happen at that moment, I think as soon as we found out, it should just be implemented today. It should be implemented right away. That's what the court order is asking for. In 25 years, you're saying, well, what goes away? Does it then go back to limited industrial, or remain as rural residential at that time in 25 years? What expires in 25 years? I think the covenants and all that were placed to protect the neighbors in that area, not to necessarily protect the landowner at the time. And again, as evidenced by our current owners who are more than willing to sell to an asphalt plant, I think that's just a little too risky to, allow anything to go automatically into motion. I think the rules, the court order ruling was to revert back to rural residential, and as far as I'm concerned, today it should be considered rural residential. Now they can submit for a rezoning and go through that process to change that, but as far as I'm concerned, it's currently rural residential. And whatever's decided, of course, you guys have the option to do so. But I think it's not the neighbor's responsibility to look after the current owners for making a bad business decision. That's just part of doing business and making investments. You win some, you lose some. It's not our job to help them recoup their losses or whatever happens.
Well, Mr. Choi, just for clarity, how long have you lived there?
Almost 30 years.
30 years, okay.
Yeah, almost 30 years, since about 89.
All right. And then you did look, I saw you had a chance to look at that modified list of uses.
Yeah, yes.
They were obviously, they're suggesting the elimination of asphalt plants and number of other items off that list. And so with that modified list, taking those items off the list, did you have any comments regarding that proposal?
Well, I think, again, it's I feel like we're kind of going about it backwards. We're trying to automatically allow things that are currently should not be allowed. It's rural residential right now. So why should we even be talking about what should be allowed? We should be reverting back to rural residential, and then let's talk about future zoning options in 2024, and we'll take it up then. And I don't understand why we're even negotiating, because the list, in my opinion, is still too broad, and it's much better. There's a lot of really bad stuff stricken from the list, but I can see there's I don't know, drilling operations, refineries, all kinds of things. I have no idea what those will be, and I feel like once we allow that to go into place today or in the near future, then that's just one more thing that's going to be recorded as if it was sanctioned and agreed upon by the residents, surrounding residents, and I think that's inaccurate and improper. I think the court order called for it. That should be implemented and move from there. Whatever. I feel like we're just kind of skipping processes here.
Mr. Choi, thank you for your comments.
Okay.
I see no other questions for you right now, so thank you for your comments.
Thank you.
Any final comments from the audience? Yes, sir. Please come back to the podium. I believe are you Mr. Mattson?
No, Mr. Duncan.
Mr. Duncan, I got you.
And just had a chance to look through the items that have been scratched out. I was familiar with the LI listing, but not what he'd scratched out. And I think looking at this list, what still remains the biggest thing that is concerned, it says manufacturing, limited, and general. That's very broad scope. That's big enough to land a plane in. And I still have some real concerns with that in a couple of other entries that are in here. Mr. Choi made a good point. We're really behind the ball. The courts should have taken action earlier, before this point, to change that zoning. It was written into the court decision on that. So I think that is something that needs to be considered as well. That's all I needed. Thank you.
All right. Well, thank you, Mr. Duncan. Appreciate your comments. Any other audience member that wants to speak on the agenda item? All right. We're going to bring it back to the board now for final comments. Commissioner Ranzau.
Yeah, I have some more questions for Justin. I'm trying to. So we have the journal entry in the restricted covenant. This idea that after 2010, I see that in the restrictive covenant.
Yes.
Is it in the journal entry?
That is not mirrored in the journal entry. And to explain a little bit, the limitation on uses that require the property, the LI portion of the property, to go to RR uses is in the restrictive covenant solely.
Right. And let me clarify. This paragraph talks about the LI property, and it seems to me that it's not really changing the zoning of the LI, it's just limiting the use of that LI property.
That's correct. This is entirely separate and distinct from a zoning case. It does deal with the use of the property, but the restrictive covenant is an agreement between, in this case, it was the county commissioners and the prior property owners to limit uses of the property, and they had it run with the land into the future for a distinct period of time.
Right, but what I'm saying is this restrictive covenant doesn't actually say that it's changed, the zoning has changed to rural residential, which would then in the future require another zoning change back to LI if necessary.
That's correct.
It just says at this point it's only going to be limited for these uses.
Correct. That property is still zoned LI. Technically, I mean, if you ask the planning commission or planning department, they'll say it's zoned LI. It's got all those uses. This is a private agreement essentially between the county and the property owners that runs until 2024.
Okay. So that is in the restricted covenant only, not in the journal entry, and the restricted covenant runs out in 2024.
That's correct. The journal entry does have its own set of restrictions on use, as Mr. Smith pointed out, but yes, it does not include that same language about reverting to only RR uses that the restrictive covenant has.
Okay.
All right. Commissioners, any other comments or questions? Commissioner Unruh.
Thank you, Mr. Chairman. I just want to kind of go through my thought process on this, of the conclusion that I'm going to arrive at. It seems that whatever year this was, 99 or whenever, that this was made against a poor actor, someone who wasn't using the property right. It wasn't having to do actually with the zoning. It was doing with someone who was violating that process, and that's why they put the restrictions on. It wasn't specifically do with what that ground is suitable for, what its highest and best use is. I appreciate the neighbor's concern, but I also don't think it's reasonable to restrict an owner's right of their property and their ability to use it within certain restrictions for what the purpose that they bought it for. You know, in my neighborhood, I don't like it when a convenience store came in on the corner. I didn't like it when an apartment house went in down the street. And so you buy a piece of property, and you would like to have control of all the area around you, but that's just not the way it works. Different property owners have their different rights. To have the control that was suggested here by Mr. Duncan, I think it's almost would require the neighbors to get together and buy the property, because that's the only way that you can have that sort of control to pass it by me before you can ask what you can do with your property. So that doesn't seem reasonable. I'm not sure that restrictions against one property owner who was violating all the rules and regulations, that those restrictions placed on that person should go on for future owners and future generations. I'm not sure that makes sense to me. And I am very encouraged by the compromise that was presented by the applicants for this change. It seems like taking out a lot of these intensive and objectionable uses would help maintain, to some degree, the integrity of the neighborhood without putting in just an intensely offensive use on the property. I know that there are property rights and people want to protect it, but the owners of this property also have certain rights that we need to protect. So for right now, that's all my comments, but those is kind of my thought process to this point.
All right, thank you, Commissioner Unruh. Other comments or questions from other commissioners? Commissioners, what's the will of the board?
Mr. Chairman, I would move that we take the recommended action here, which is first authorize the county council's office to prepare the chairman to sign a document that would remove restrictions contained within the declaration of restrictive covenants, such that said document is to be recorded with the Register of Deeds. Second, authorize the county council's office to file a motion with case number 98C 3245 and effectuate any other documents to be filed with district court that would remove restrictions upon the use of the property included with a journal entry of judgment dated August 18, 1999. And thirdly, I would include in the motion that we include the exceptions as suggested by the applicant as restrictions on the zone.
All right.
I'd second that.
All right, thank you, Commissioner Unruh and Commissioner Norton, for the motion and second. Are there any other comments or questions? Commissioner Ranzau.
Okay, so let me understand what we're doing here.
May I speak, Mr. Chairman?
So are we nullifying these, or are we just amending it? I guess.
No, we're going back to LI zoning with these restrictions, as the suggested by the applicant here, or the requester, or whatever the right word is.
And that's my understanding as well, Commissioner Ranzau.
Well, as a matter of law, can we make essentially a zoning change without going through the zoning process?
This isn't a zoning change. So to answer your question, yes, we can do this. The restrictive covenant says as long as majority of the county commissioners, and presuming that the current property owner would agree to these changes, which they've indicated they would, then yes, we could change the restrictive covenant. We would require a court to, we'd file a motion, either we would or the property owners could as well, to modify the listing of restrictions to eliminate the restrictions that are currently in place, but putting in place restrictions, as Commissioner Unruh's motion noted, that were indicated in that document, that are LI uses that would not be allowed. That would not be a change on the actual zoning of the property. It's just a change on the use.
Okay, let me clarify then. That was my question. Then we're modifying the covenant. We're not eliminating the covenant.
Correct. Correct. That would keep the covenant in place. The presumption here is the covenant would stay in place through 2024 with a limited listing of a revised listing of restrictions.
And then we would ask the court to modify the journal entry to reflect that?
Correct, in a similar fashion.
And so, okay, is that the intent of the motion and okay with the landowners then? Okay.
All right. Thank you for your clarification, Commissioner Unruh and Commissioner Ranzau. Commissioner Peterjohn has other questions or comments?
Yes, a question for Mr. Miller. The question's been raised about limited and general manufacturing, and manufacturing was not on the list. I'm curious in terms of understanding with the current zoning what the difference is between limited and general, and if that would fall into the current properties that are around that are within K.S.A that we talked about that had the industrial zoning.
Manufacturing limited is essentially a low-intensity type activity where, by definition, it's an establishment that is engaged in the on-site production of goods by hand manufacturing that generally involves only the use of hand tools or other equipment not exceeding 2 horsepower and may include assembly and packaging as well as incidental direct sales to consumers of those goods produced on site. A list of typical uses include ceramic shops, custom jewelry making, computer product assembly, that sort of thing. The general manufacturing is an establishment again engaged in the manufacturing predominantly from previously prepared materials or from lightweight non-ferrous materials of finished products or parts including processing, fabrication, assembly, treatment, and packaging of such products, and incidental storage, sales, and distribution of such products.
Thank you for that clarification.
Thank you, Commissioner Peter John. Commissioner Ranzau?
I'm sorry, one more question for Justin and maybe my fellow commissioner here. There's been some discussion about when this covenant ending in 25 years, but it's not in the journal entry. Is there a need or desire to address that in the journal entry as part of this decision making?
The journal entry incorporates the restrictive covenant. I would imagine that in the journal entry, what we would seek to modify in front of the court would be to note that the restrictive covenant's been modified. And I mean, we could add something in there that says it ends, 25 years from the date it entered into force. But yeah, I mean, that's very clear. Does that answer your question? I'm sorry. I think.
Well, it seems to me that it would be a good idea to make both of them consistent.
We could add that in there.
To avoid any. Okay.
And so, I guess just to make clear, the question that I might have on Commissioner Unruh's motion would be: is the intent to have the journal entry, the application of its terms only apply until 2024 as well? Was that your intent in the motion, or is it to have it apply indefinitely?
No, only to the term that was originally established.
And I would say, and I'd let Eric comment if you wanted to, it might make sense to clarify that and make sure the second on the motion concurs with that as well.
I think if the parties are in agreement,
okay.
Eric Hills, County Councilor, I think if the parties are in agreement, they can extend the life of the journal entry if they wish. They can leave it right where it's at now. They can amend the journal entry. So it's whatever the will of the commission is and whatever the landowner would agree to. And I think the intent of Commissioner Unruh, I'm taking it right now, is we're not extending the life of the journal entry.
Right.
We're simply modifying the covenants within that journal entry.
And I thought that's the intent of the motion.
That's how I took it.
Recommended action.
That's how I took it.
Thank you.
All right. Any other comments or questions from commissioners? Okay, I think we have a motion and a second. And see no other discussion. Madam Clerk, please call the vote.
Commissioner Unruh?
Aye.
Commissioner Norton?
Aye.
Commissioner Peter John?
Aye.
Commissioner Ranzau?
Aye.
And Chairman Howell.
Aye. Thank you, everyone. Next item, please.
Thank you, Commissioners. Justin Wagner. I'm sorry. Sorry, I got ahead of the game here. Go ahead.
Item D, island annexation request for the city of Clearwater.
All right. Justin Wagner, Assistant County Counselor. And I'm here for another item on this annexation matter. I'll pull up the map here. What's in front of you is a proposed island annexation by the city of Clearwater. As you know, an island annexation is when the land that's proposed to be annexed does not actually adjoin the city's boundaries. Referring to the map that's in front of you, the proposed property that would be annexed is in red. The city limits for the city of Clearwater are kind of the peach tannish colored properties, and then the blue line indicates the urban area of influence for the city of Clearwater as indicated within our zoning code. This property is within Prairie Meadows Estates subdivision. It's one of two subdivisions north of kind of the core area of the city of Clearwater, in which there's been a number of properties as homes are built in these subdivisions where the property owners petitioned to annex into the cities. This is because they want to join on to the city of Clearwater's water supply because the property is not suitable for wells. The Metropolitan Area Planning Department completed a staff review of this proposed annexation and recommended that the Board of County Commissioners find the proposed island annexation would not hinder the proper growth and development of the area nor any other city within Sedgwick County. If this annexation went through, the city would provide police services to the property, which are currently provided by the sheriff. The city does not have any plan to extend sewer services to this property, as I understand it. The city and Nenaskaw Township have an agreement regarding road maintenance where the township would continue to provide road maintenance in this area. And since this property falls within the Clearwater Fire District already, there wouldn't be any change to who provides fire services. No other city in Sedgwick County has indicated that this parcel is part of their future urban growth area. And the state statute requires the land, in order for you to indicate an approval of this island annexation, It really requires a finding that the land is required to be located in the same county as the city, which it is. The owners of the property must petition or consent to the annexation, which that has occurred. And then the last one would be that by a 2/3 vote, you would have to make a finding the annexation will not hinder and prevent proper growth and development of the area or that of any other city within Sedgwick County. The recommended action is to make the finding on the last item that there is no, that would not hinder or prevent the proper growth and development. And I'd be happy to stand for any questions you have.
All right. Well, thank you, Mr. Wagner, for the presentation. And I'd like to go to Commissioner Norton.
Justin, this isn't the first piece of property that has gone through this process in that area, is it?
Yes, this is not the first. This is, I think, the 21st, if I remember correctly, of these properties.
And this is happening as they build out, they request to go into the city limits as each new property is added on. Is that
That's correct, Commissioner Arnn.
I would make the motion for the recommended action and embrace the findings that Justin has brought forward to us.
Second.
Very good. We have a motion and a second. And Commissioner Peterson, do you have any comments right now?
Yeah, I would just like to, we've been through this a number of times. I am very cautious when it comes to island annexations, and that when we get into a situation where they're separate, and this is separated by a good deal of distance, but we have done this in this general area numerous times before, and that's why I seconded this motion. And but it's something that I think this commission needs to be cautious about going forward, because if future cases come up, I do have some concerns in terms of how this might impact also the effort to expand the zoning areas of influence for the city too, if the island annexations become quite commonplace. But I will be supportive of this motion today. Thank you.
Thank you, Commissioner Peter John. Seeing no other comments at this time, I'd like to go to the audience and see, is there anybody here that would like to speak on the agenda item? All right, seeing none, bringing it back to the board. Any other comments or questions from commissioners? We have a motion and a second. My only comment would be that, again, I'm supportive of the motion this morning. I think this is fine. It's doesn't seem to be any opposition to the annexation of this single property, but I am very sensitive. Every time we lose revenue to the fire district, I'm concerned a little bit about that. So I don't know. Does this impact the fire district revenues in any way?
I don't believe this would, because it's already part of the Clearwater Fire District.
Okay. I want to make sure I understood that. Very good. All right. Well, thank you very much for that. Any other comments? Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh?
Aye.
Commissioner Norton?
Aye.
Commissioner Peterson?
Aye.
Commissioner Ranzau?
Aye.
Chairman Howell?
Aye.
Thank you, Commissioners.
Thank you very much. If you don't mind, I think at this time we'd like to take about a 5-minute recess. I perceive we've got a little bit more time left on our agenda, and so to split the remaining agenda, I'd like to go and just take a 5-minute recess. We'll come back at 10:45. Thank you. All right. Well, everyone, thank you for coming back to the commission room. We're going to call us back to order at this time. Madam Clerk, next item, please.
Item E, amendment to the capital improvement program for courthouse lobby gun lockers.
Good morning, Commissioners. I'm Steve Clausen, Operations Support Services Director. This agenda item is soliciting your approval to amend the capital improvement plan to include a project that would provide gun lockers for the public's use, located in the main county courthouse, front entrance lobby, just in front of the current X-ray and magnetometer screening line. As you know, Kansas law allows open carry and concealed carry of firearms for eligible citizens with some specified exceptions. One of those exceptions is in public buildings such as ours, our main county courthouse, where adequate security measures are in place. Currently, anyone in possession of a firearm that comes to the courthouse is turned away. This project would provide a reasonably safe place for those folks to stow that firearm while they are in the building. It would provide 20 such gun lockers within an area that would be modified to provide reasonable protection against possible accidental discharges. On the display, we're showing a screen that has the floor plan of the modifications that are going to be necessary in order to provide this gun locker location. Outlining, so this is the northeast corner of the main county courthouse entrance. The revolving door might be a landmark for folks to know this is the north revolving door providing entrance into the building. These double doors here that I'm showing are the exits, and it's in this area right here that we are proposing the gun locker location to be provided for. These rectangles here describe the location of where those gun lockers would be located. This image models a view taken from the perspective of a person standing right in the middle of the entrance lobby, in front of EULA's desk, if you will, or the reception desk, looking north at that location where these gun lockers would be constructed. There's a person in this image, a wheelchair located there. He's just approaching the gun locker area, and this image is the same point in time. Again, that wheelchair-bound person kind of provides the landmark or anchor for this picture. He is just about ready to go into the area that's being provided for the gun lockers. The modifications necessary to get this done and provide the safety that we think is necessary is the construction of these walls to be built out of materials that are aesthetically similar, probably the very same, that are used at the rest of the window wall system on the exterior of the building. So it'll be aesthetically satisfactory. I don't think it'll be objectionable to anybody's eye. The glass used in these areas would be of a ballistic grade sufficient to protect against a .357 Magnum discharge. And then beyond that, in the existing window wall, I'm going to go back to the floor plan. This is the existing exterior window wall system of the building. In this area, again, to make sure that an accidental discharge didn't cause a problem to somebody approaching the building, we would remove the existing glass, modify that aluminum window wall system to accept the new ballistic glass, and thereby we would have a well-protected area for nearly all accidental discharges that might occur and protect people in the surrounding areas. It also would give our courthouse police the opportunity to see exactly what's going on inside that protected area. It'd be easy to take care of the scrutiny that needs to be provided for that. The cost of the CIP is $64,318. The fund source is recommended to be the CIP Reserve Fund. I need to mention that the CIP does not include any additional courthouse police staff or any added monitoring and administration that's maybe necessary for this operation. Courthouse police is going to make their best effort to make this work with the staff that they now have. I have Daryl Haynes, our courthouse police chief, here with us. He or I would be available to answer any of your questions about this. The recommended action is to approve the capital improvement program amendment, and we'll stand for your questions.
All right, well, thank you, Mr. Klossner, for the presentation, and I would like to take this to the audience and see if there's anyone here that would like to speak on the agenda item today. All right, seeing none, bringing it back to the board. First comment I would make is the artwork on this is tremendous. I've never seen artwork quite like that. I don't know how they did that, but it looks exactly like the lobby. I mean, it's very, very well done. So, impressive presentation in the slideshow this morning. Commissioners, any comments or questions or motions for the agenda item?
Mr. Chairman, I move we take the recommended action.
All right, we have a motion, and I would be glad to second that. Any other comments or questions from commissioners? Commissioner Norton.
Well, I have a concern that it's a pretty healthy expenditure out of our reserves. I wish we had gone through a normal budget process to be able to do this, to have more conversation, not only on this item, but we talked about the pass cards today, which now changes the dynamic of our courthouse system and how people can enter the courthouse concealed or carrying and everything, and that becomes a broader scope of what we need to be thinking about as far as security. This is part of that, but it is a budget item that is extemporaneous to what we went through all of last year trying to think through this. I'm a little concerned, number one, about the oversight too. We're not adding any folks to be there to really see what goes into the lockers. I know there's been some concerns that unless you can really oversight it and see somebody is putting a weapon in there, they could put other items in there that may not be weapons, and that we'd have to deal with that in some manner. That oversight issue concerns me just a little bit. Now that adds money to it because it becomes operating, but I just see that there could be a misuse without some kind of oversight. And then I have some concerns that this didn't go through a normal budget process. We're just adding that much expenditure. I have gotten emails from people once they saw the article, and I have not gotten an email that would substantiate that we need to even do this. I've had several that didn't think the expenditure was prudent, and that if we were going to do it, that maybe we have some way to charge people for using a locker for that particular item. And the final thing is, over the years, I have gotten no complaints from anybody that we didn't have a way to secure their weapon as they entered the courthouse. So, just some comments.
All right, thank you for your comments, Commissioner Norton. Other comments, Commissioner Unruh.
Thank you, Mr. Chairman. Well, first of all, I need to say I have my concealed carry permit. Thank you, Chief Haynes, for helping me get through that. So to kind of establish my perspective on firearms and Second Amendment rights and those sort of thing. But on this particular item, I've got a lot of questions, and some of them are like Commissioner Norton said. I have received several emails, one of them in support of this, but half a dozen of them that were opposed to it, varying degrees of expressing their position. But there were some people who said, well, if you got to have it, since this is not, in county parlance, this is not an essential service, have we done anything to investigate what it would take to make it self-supporting financially? Mr. Clausen, have we done anything there to figure out, I mean, how much would it cost? Could we do it? Can we charge somebody a couple bucks to store their gun?
I think we could certainly do that. We have not done any projections on how we would administrate something like that. Certainly, you could impose a fee for that use.
Well, we have fee for service for a lot of other items, like, you know, using your credit card or, you know, online tag renewal and those sort of things. So I would think maybe we could implement this to offload that expense. And I don't know what it would take to do that study. Another question I had, does this increase our liabilities in any way? I mean, it's clearly an exposure. I mean, do we have, I mean, how does that do to our risk management?
Commissioner Unruh, John Von Atchen, Assistant County Counselor. This has been part. This allowance has been part of the statute for quite a while, and it included in that is that there's no increased immunity or no increase in risk. The immunity still stands for us regarding if we do this or not. There's also, to answer your previous question, there is no statutory discussion at all about an allowance or disallowance for charging for the service. You know, other parts of the statutes related to firearms and public buildings do have prohibitions as to what you can actually do. This section actually does not have a prohibition regarding whether or not you can charge, if you do provide gun lockers, whether or not you can charge for them.
So we're not prohibited from charging?
We are not prohibited from charging.
Okay, but the equipment that's contemplated probably doesn't have a coin slot or a dollar slot or anything like that. Is that correct?
That's correct.
So we need somebody there to monitor it.
That's right.
But you said we weren't going to have someone to monitor. We were going to use our best effort. I think that's the term you used.
That's exactly right. We're acknowledging that this will be an extension of the responsibilities that the current staff of the courthouse police has to provide oversight for, and they're going to do that. We also believe there's consequences to that, which would include slowing the lines down, because when we divert one officer's attention away from what his primary assignment is, it's going to have a consequence. So the officers are committed to monitoring what goes into those lockers, to keep an eye and making sure that the weapons are not handled in a cavalier way. There's some reasonable safety being used and they'll be able to see into this area so that can be done. So it is an additional task that courthouse police will have to do. The additional task of dealing with a money issue would further extend that. And I think, I should probably let Daryl, you want to speak to this, how we deal with this?
Well, what I would anticipate, Daryl Haynes, Courthouse Police Chief, what I would anticipate is that we would have the person who wants to check a gun contact an officer, that we would provide them a key, that they would use the key to open the locker. They'd remove a 3x5 card that's laminated or some sort of plastic card. They would carry that with them. They'd secure the gun in the locker and return the key to us. They'd go about their business, and then when they came back, they'd provide us the card. We'd provide them the key. They'd take their gun out. No loading or unloading of the gun would be needed or probably a good idea. It would simply be put in the locker and taken from the locker. We will need a body to monitor that, to make sure something nauseous or explosive was not put into the locker. Realistically, it just depends on how much demand there is for this. If it's 3 a day, it's not much. We can handle it. If it's 20 an hour, We're going to fill up the lockers pretty quick. We do have provision where we could add an additional set of lockers, 20 more lockers in short order. So that's kind of the procedure I would anticipate at this point in time. And I think it is definitely necessary to monitor what goes into the lockers to make sure it's not something inappropriate that could cause harm to the building or the people in it.
Okay, so how many lockers are there going to be?
There are 20 lockers in the cabinet that we have, and the 20 lockers will probably be adequate, is our best guess. If there is more demand than that, there is sufficient room within the enclosure that's planned to allow another set of 20 lockers. I really don't ever think we'd get past 40 guns at one time.
And that's just your sense of the matter. I mean, we haven't done any polling or done any research to see how many people might use it.
I have no idea how many people would want to use this.
And so, Chief, did you say that is your officer going to take the weapon and put it in, or are we just going to give it a card and they put it in?
The officer will remain outside the ballistic enclosure and monitor what goes in it.
And watch what goes in. And we're not hiring an additional officer?
No.
That was your request, to hire another officer?
You know, I think the best way to put it is, I think we can get by at least until we know what kind of demand there is. But you combine the gun lockers with Fast Pass, and it's going to change the complexion of how things work. I don't know if it's going to be for the better or for the worse. We'll just have to monitor that and find out.
Oh, okay. Well, I don't think that you have too many folks down there right now, do you?
We have had a couple of layoffs through the years when the county was on hard budget times, so we're a couple positions short of what we were at one time. We're not long on people,
okay,
but I think at least initially we should be able to get by.
Okay, but it's with the staff you have and the need to monitor this, which I think is definitely a need. And the fact that some guns are going to be loaded, probably. I mean, people don't carry unloaded guns, I don't suppose. And they're not going to load and unload them there, so we're handling loaded weapons. But none of that's going to affect our liability. Is that what I was told? I mean, we don't have any more exposure. Is that? I mean, I think you answered that. I'm asking again, I guess.
Just so I understand the question, Commissioner, is there an additional risk of something happening? I think the answer is clearly yes. Do we have any additional legal exposure from a liability standpoint? The answer is no. The legislature, in the process of passing these bills and getting the adequate security measures in place and allowing for the policy that we talked about earlier today, in doing all of that, they made it clear that if you adopt anything that is supportive of that you will face no additional legal liability, and they've actually incentivized a little bit for other entities to adopt these measures, so that by saying you will gain no additional liability by adopting measures such as these. So, from a legal perspective, there's no additional liability, but from a perspective of are we introducing something that could potentially happen where there's a risk of accidental discharge or something more heinous occurring? That's possible, but we're not facing any additional legal liability.
Okay, thank you. Well, I guess that's all I have. Maybe, I don't know if I need to summarize my thoughts now, or, but my thoughts are this is not, as we've described in our budget process, an essential service of county government. It is $60-some thousand. I have not, I'm similar to Commissioner Norton, I really have not had anybody asking for this in my 14 years as a commissioner, save one person. asked a few years ago. So I personally don't see the risk walking from your office or your car to the county courthouse when you know you can't carry that weapon inside the courthouse. And so when I add all that up, it adds up to me that I don't support this agenda item. So that's all I have, Mr. Chair.
All right, thank you, Commissioner Unruh. Commissioner Peterjohn?
Thank you. Chief Haynes, if I can ask you a couple questions, and I guess I'll begin for the record to add that I very much appreciate your efforts to educate me on firearms too. But having said that, how many positions are there you currently have filled in the courthouse police right at the moment?
Do we have open?
No. How many total positions, employees do you have right now?
We have approximately 32, including part-time. The bulk of it, we have 17 commissioned officers, and then we have some non-commissioned service officers, primarily on second and third shifts.
Okay, because there was a question about that. Could these lockers be used for knives, for instance?
When somebody comes in that's carrying a knife, we take or mace or anything of that nature, we take that from the person. We write down their name and telephone number and address so we can try to get it back if they leave it behind. We also ask them for a set of keys or a driver's license to go in with it. So so they have some incentive to come back and before they go to their car and not leave it at the courthouse. But they come, they check it once they go through screening. We check it right there at the back counter, and then once they've conducted their business, they come back. They ask for it by name. We keep it in clear envelopes. We hand them their knife back, and then we make sure they exit the building with the weapon.
When I became a commissioner in 2009, I was told that knives were being confiscated. When did we change our policy on that?
I wasn't here then, and I don't know the situation, but since I've been here, that's the procedure that we've used.
Okay, but these lockers could be used for storing knives also?
No, I don't anticipate that. I would not recommend that. We actually do quite a volume in knives, and we realistically, if we do the gun locker, we need to have the lockers free for guns only, and not for cell phones or anything else somebody might want to put in there.
Yeah, because Steve mentioned in his presentation wheelchairs, and this may be a question for Mr. Clausen as opposed to yourself, Chief. This is ADA compliant? And will
yes, the architect has inspected it for that type of purpose,
Okay. Well, I'm going to make another comment. I mean, the question of cost has come up here. We're talking about $64,000, which is a significant sum, but I know we've taken up, as a commission, since I've been up here, we've taken off budget items literally in the millions and brought them up in the middle of the year. So, and in light of, I think, some of the other efforts that we've made to economize on some CIP projects, I don't find that argument very compelling. But what I do find compelling, and I want to kind of provide this, I brought my Kansas election statistics and from 2010, and the reason I brought that was the Kansas Constitution had a provision about the right to bear arms, and it had said in the Kansas Constitution, people have the right to bear arms for their self-defense and security. Unfortunately, the Kansas Supreme Court, in their judicial wisdom, and this goes back a ways, it wasn't a real recent case, they basically said, well, you're just referring to the militia then, you're not referring to the people. Of course, it showed their historical ignorance, because anyone who understands the history of Kansas would know that that was bunk. In 2010, an amendment was proposed to the voters in this state and approved by the voters that basically said, and I'm going to quote here, a person has the right to keep and bear arms for the defense of their self, family, home, and state, for lawful hunting and recreational use, and for any other lawful purpose. And when the voters had the chance to opine on that, this was passed in Kansas with over 88% of the voters saying yes at the November 2010 general election. In Sedgwick County, it was 116,557 votes yes and 14,214 votes no. I mention this because that is the reason, in part, why we are here today, in my view, for this issue and the issue that was mentioned earlier. There had been a lot of debates prior to this concerning concealed carry, and the opponents of concealed carry had said, this is going to be awful and it wasn't going to be a good idea. Well, Kansas was one of the last of the 50 states to move in approval of concealed carry. I think we were among the last 3 or 4 who did so. But none of the negative effects that were pointed out at that time occurred. I mentioned this for folks who weren't around there at that time, and I provided for the public. Probably won't get reported. I think of some of the information that was presented last week in our discussion on other topics that didn't get reported, but I'm putting it on the record here today because I think it's important going forward, and whether the print media decides to pick up on it or not. And I am looking at you, Mr. Salazar. I'll be happy to visit with you either publicly or privately on your coverage. I'm going to provide this for the record because I think it's important to understand the context of why we are proceeding here today. More recently, open carry has been provided, and that is current Kansas law too, under this constitutional amendment that the voters, almost 9 out of 10 voters approved at the 2010 general election. It doesn't get mentioned very often because it's politically incorrect, but I'll mention it today and reemphasize it for the record. Because when I first came here, I had, in past life, I'd been an engineer, and one of the things I did was I used to carry a Swiss Army knife, the old Boy Scout habit of mine. I was a Boy Scout once upon a time, and I was shown, these dangerous 3-inch blades that were being brought into the courthouse and confiscated, and I know we've moved away from that and into an age of responsibility. So I want to make sure that people understand the context of why this issue has appeared. Frankly, I was surprised it didn't appear sooner. And I have had folks contact me both for and against it. And I find, frankly, under the idea of where we're at, what's the other option out there? People, if they can't bring them into the courthouse one way or another, they end up having to keep them out in the car, and the problems that can occur from that. I think moving in this direction is the right step. So I will be supportive of this proposal today, but I want to make sure that people understand the changing times that we're in, and that is a factor in my support for this motion this morning. Thank you, Mr. Chairman.
Thank you, Commissioner Peter John. Other comments, Commissioner Ranzau?
Thank you, Mr. Chairman. Yeah, I'll have several things to say. I want to follow up on some of the things that my colleagues have said. First of all, I want to correct a statement or clarify. Protecting individual freedom is an essential function of the government. In fact, it is the core function of government. We must remind people that we institute government among men to protect their individual rights. Among them is the right to keep and bear arms. So this absolutely is a core function. And we've created a situation here which we said that the citizens cannot carry weapons into the courthouse. But how do they get from the parking building or wherever they walk from there to here safely? That's a legitimate concern for them. Now, I've heard from many people throughout the years, specifically a fair number of women who are concerned about this. I take those concerns very seriously. I don't belittle them or downgrade them. I think over time, citizens know which commissioners will be open to their ideas and suggestions when it comes to the Second Amendment, and those who are not. So obviously, I think we hear more of those. It's interesting. Out of all, there's a lot of people that come to this building. Citizens, employees, most of whom have to walk a certain amount of distance. I've heard it been said that at least one of my fellow commissioners doesn't understand the risk. Well, I think it's important to point out that the two commissioners that will likely oppose this enter and exit through a restricted and locked exit into a restricted parking lot, and literally the back door is 5 steps to their car. So they face a lot less risk than anyone else who has to enter this building. So it's easy why they may not understand that or take that into consideration. But the risk is, at least in many citizens' minds, an issue and a concern. So we're taking steps to address those concerns. Now, that being said, $60,000 is a fair amount of money. And if my colleagues have more cost-effective alternatives, I'd be happy to entertain them. That being said, I don't think we'll hear any. I am intrigued by my colleagues' concern for the taxpayer today, considering in the past that in the not too distant past, actually, we've spent upwards of $170,000 to advance both the nanny and welfare state ideologies under the name of protecting public health and safety. In fact, last week we spent $115,000 on 2 positions that staff testified said we don't even need to meet the community's needs. Yet when faced with the opportunity to protect public health and safety by promoting constitutionally protected individual rights, they say no. That leads me to believe that the opposition really isn't about money. It goes back to the same old ideological arguments of collectivism versus individual freedoms. And I think it's very clear where I stand. We do have an obligation to protect individual freedoms. And so I do consider this to be a fair amount of money, and I would like to see more cost-effective alternatives if everyone, if anyone has those options, but I've not heard any. And once again, the idea, how can we on the one hand say that we'll spend hundreds of thousands of dollars on promoting positions and welfare and anti-state programs that don't work or aren't effective, or positions that aren't needed, but when it comes to protecting individual freedoms, we're not going to do that. This is a safety issue as well. Okay, and so I'll be supportive of this. I do have concerns about the proposed process. I think it is too complicated, and I think we should reconsider how we do that, but I think that'll be manageable as we move forward. It's one of those things, it's the cost of doing business. I wish we didn't have to do this, but I think it's the reasonable and prudent thing to do. And like I say, if anyone can come up with a more cost-effective or alternative, I'd be willing to entertain that. Additionally, if my colleagues want to reconsider some of the previous votes to spend what I consider wasteful and unnecessary spending to promote their ideological agenda, then I'd be willing to reconsider this one as well. But right now, I think I'm going to continue to support the individual right to keep and bear arms, and I'll support this agenda item. Thank you.
Thank you, Commissioner Ranzau. I've got a couple of comments and questions. Mr. Clausen, can you please talk about the construction listed on the item here? It shows $58,000, almost $60,000. But how much of that is actually the lockers versus the enclosure? In other words, there's a glass and metal pieces that have to be installed. So how much? Can you break that down a little bit for me?
We have the lockers in our possession now, so the dollars identified in this CIP are absent any costs for the lockers themselves. The lockers are about little under $5,000 a piece for the 20 set lockers, but that is not we own those now, and that's not a part of this request.
So one option, of course, is we don't have to do anything at all. I mean, that's obviously an option here. But when we started going in this direction, and there was some discussion, I know I've had discussion with you early about providing lockers, and one of the plans that was presented back to me was hiring of staff and just placing the lockers there without the enclosure. That enclosure was something that came up later. Again, I'll just take credit for that right now, that the enclosure to me is part of the necessary expense because, and I'll use the word transition zone, somehow you've got to get that gun off the person and into a locker. And I know that when people handle the firearms, again, this is including commissioned law enforcement officers, it doesn't matter who they are, human beings, when they handle a loaded firearm, that's the time, if there's ever going to be a accidental discharge, that's the one time that might happen. I trust our citizens the same as I trust the police officers. I think that they're trained and experienced and they handle these firearms, especially if they're someone who carries firearms regularly. I'm not concerned about their being unsafe necessarily, but again, I want to be sensitive to the fact that someone's transitioning a firearm from the person to a locker, and if there's ever going to be an opportunity for someone to have an accident, that would be the time that would happen. So this transition zone, the safe zone, is the time that I think it's necessary to have that as part of this plan if we're going to have lockers. So the initial plan was to have lockers, and the courthouse police would actually take that firearm and they would lock it up. I guess they would have the keys. They would actually place it in the locker. They would retain the key. What this has done is this has changed it from that initial idea to basically the courthouse police are now observing. In fact, we also have video monitoring and I think recording of the area that the transition would happen. So we don't want someone to walk in and pull a gun off their person and do anything in the lobby until they're inside that transition zone. That's the area that they should transition the firearm to the locker. And then our courthouse police are not handling the firearm. There's no reason for us to handle it. Had we gone with Plan A, I'll just use the Plan A as what was initially presented back to me, it would have had a recurring cost of at least one courthouse police officer, and I'm not sure, maybe more than one. And I don't know what they make. I probably should have looked this up, but I think that the recurring costs tells me that that would have been a larger expense over time. Maybe not initially, but at least over time it would have been a higher cost. And so, anyway, I just wanted to confirm some of that. I agree with the comments made by some of the commissioners here today. I am sensitive to the fact that when people come to this building, many of them, if not most of them, are not here by choice. They're here because they have to do business in this building. And if they want to go to Interest Bank Arena to watch a concert, that's a choice they make. They do have security measures over there as well, but again, you have to understand what you're getting into, and if you want to participate there, it's a choice that you make. You can do it if you want to, and you don't have to. But people don't have that choice here. There is a constitutional aspect of this, and that is people have a right to be protected. And as much as I love our police officers, and I think they do a tremendous job, ultimately they cannot protect the citizen independently and individually wherever they happen to be. And that's why we have the constitutional right has been clarified by our Constitution that they have a right to protect themselves. And I encourage people to do that, to be trained and to know how to do that, and to take that very seriously. And many citizens have done that. In fact, over I think 110,000 citizens in our state now have concealed carry permits, even though it's not required now to have a permit to carry a firearm concealed. I believe 110,000 people have done the training necessary to have that permit, and a lot of them do carry. People who carry firearms are not to be feared. Many of these are excellent citizens. Some of the best people we live with are avid carriers, and they are good people. And they have a right to carry those firearms. They have a right to be protected. And if they want to do business in our facility, they ought to have the right to be protected all the way to the facility. To me, that's a fundamental aspect of this that needs to be discussed. And so, to me, this transition zone affords them that right, that they can be protected all the way to our facility. If they want to exercise that right, they can. They certainly don't have to, but it provides a way for this to happen, sensitive to the constitutional rights. So to me, this is just a necessary expense. And again, I'd like to just also make the point that, yesterday we celebrated the opening of the Ronald Reagan building. And as great as that was, one of the points that was made that I don't think it made the paper or the media, was that we saved $10.2 million in our CIP budget because we were sensitive to trying to do things that make sense. And we reevaluated some stuff. And along the way, we saved $10.2 million. And some of in 2014, the expense it was discussed at that time would have been almost $21 million if you added up all the costs. And as it turned out, again, extrapolating the cost for the top 3 floors, which has not actually been completed at this time, but we believe our total cost will be a total savings from that initial discussion of about $10.2 million. So, we're saving money there. $60,000 is arguably a lot of money. I agree with that, but you got to keep everything in perspective here. In fact, I would say we also, can you please confirm how much did we spend in this last year on upgrades to our video system in this building to enhance our security in this facility?
We've spent dollars. I don't have that at the top.
But it's significant.
It's been
very significant.
That's right.
In fact, the area that we're talking about for this gun locker enclosure.
How much we've spent on video enhancements to our courthouse?
Not much in recent years. Probably.
We've added cameras. We're unclear about what the dollars are.
Well, there have been some enhancements that have been done just this year, and in fact, the area that we're talking about for this gun lobby or gun locker area has already had some camera drops and things like that added to that area, even before this was even discussed. So,
yes.
All right. Just a couple other points. I had someone who I'm familiar with this case. He purchased a knife at Gander Mountain. He went into the city hall to pay a ticket and was arrested because of the knife that he had on him. They look at him like he's someone who's going to commit a crime, I guess, there with the knife he purchased at Gander Mountain. So it's a small 2-inch knife, roughly. But because that was, at the time, it was considered not allowed under the state law, citizens at that time that had that type of knife were just arrested. And so actually he's a deacon in a church and a missionary, a tremendous citizen. But yet that's what happened because our policies treat sometimes our citizens who do business in these buildings as if they're bad people. And majority of the people who come in these facilities are great citizens. And those that want to do harm will do harm regardless of these policies and these laws. They'll make choices to do whatever they want to do regardless of stickers on windows and things like that. This is not going to change the nature of people who are intending to do harm. This really just allows law-abiding citizens a right and the opportunity to exercise their rights under the law in the fullest extent. So to me, this makes a lot of sense. I've said plenty. Any other comments or questions from other commissioners? All right, seeing none. We have a motion and a second. Madam Clerk, please call the vote.
Commissioner Unruh?
No.
Commissioner Norton?
No.
Commissioner Peterjohn?
Aye.
Commissioner Ransaw?
Aye.
Chairman Howell?
Aye. Thank you, everyone, for the discussion today. Madam Clerk, next item, please.
Consent agenda.
Commissioners, Mike Scholes, County Manager. Recommend you approve consent agenda items Foxtrot through Oscar or F through O for the counselor.
So moved.
Second.
We have a motion and a second. Any discussion?
Chairman.
Yes, sir.
David Spears, Director of Public Works. I think it's significant to point out to the public that item F, we are going to receive $958,375 from the federal government with no match from the county for 4 railroad crossings in the county, and that would be to put flashing lights and gates there. So that's a pretty significant thing I just wanted to point out. And I won't name off the streets, they're on there, the roads, but we're very happy. We're very happy about this, and hopefully it will improve the safety at those locations.
Well, very good. Thank you for the information. It is good news. Any other comments? All right. Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh?
Aye.
Commissioner Norton?
Aye.
Commissioner Peterjohn?
Aye.
Commissioner Ransaw?
Aye.
Chairman Howell?
Aye. Thank you. Next item, please.
Legislative issues.
Commissioners, anything for legislative issues this morning? Or counselor? Any issues? Okay. Not at this time. All right. Next item, please.
Other?
Commissioners, any comments for other today? Commissioner Peterjohn.
Well, thank you, Mr. Chairman. I'm going to begin on hopefully would be considered a little bit of a lighter note in the county's efforts to raise a significant amount of sum for the United Way. I want to congratulate the survivors of the dunk tank on Monday, specifically looking at Councilor Yost, County Manager Scholes, and I believe the best dressed donkey of the day, Chairman Howell. It was, I think, a very useful event for employees. We honored, also as part of that event, honored employees for for their years of service, from 15 years on up, as well as some employees for outstanding performance. I also wanted to mention, because I think it deserves as much attention as possible, that yesterday we dedicated, and I think this is kind of the completion in the effort to combine with the MABCD is what we call what it's commonly called, but at the Ronald Reagan County building, a dedication yesterday, and the fact that there were significant savings over some of the initial costs have been brought out, and over $10 million, and I'm very, very proud of that fact in light of the challenges that we've had in combining those departments and putting our community in place, I think, to be much more competitive in the 21st century. And as soon as we get the automated computer, the ability to present plans via computer and move away from the printed plan model, I think that's going to be a huge plus for us as a county and a community going forward. And I think that's a very important point, because there is an awful lot of work that's been done by staff. There were a lot of input from folks from the private sector, and I think it's going to be a big plus for this county and the city of Wichita going forward. I'd also be remiss if I didn't point out that October 12th is an important day in our history, and point out that on October 12th, 1492, 3 little vessels with a crew of only 90 people, Christopher Columbus brought the Nina Pinta and Santa Maria and landed on what he called San Salvador, but which we'd call today one of the Bahama Islands, and actually found and started the process off of recorded exploration in North America, which is why Monday we had it as Columbus Day and a celebration here. A little bit more recently, we've had some important events that occurred on October 12th, and some of them are not quite as positive. In October 12th, 2000, we had, as one of our presidential candidates referred to it, Islamic jihadists. I'd call them illegal combatants. Some people might call them suicide bombers. Rammed the destroyer, the USS Cole, set off an explosion that killed 17 American sailors. And so October 12th is a very significant day in our history, and I just wanted to get that on the record. Thank you, Mr. Chairman.
Well, thank you, Commissioner Peter John. Commissioner Unruh.
Thank you, Mr. Chairman. I just wanted to say that, along with others, I'm pleased with the savings we had on the Reagan building, and I think it's significant. But I think that that comment requires a footnote and a clarification. We're claiming savings for the tag office that was going to go into that building, and rather than go in that building, we spent $2 million over on Douglas and Meridian, which was a good investment. It's working out great, happy to do it. But at that time, we also claimed a $2 million savings for that building. So we're kind of doubling up on our savings here. There's about $4 million in this $10 million that we've already claimed somewhere else. And I think that just a footnote for accuracy. And the savings we have on our long-term bond financing, which was, I forget the number now, but that's won't be realized for 20 years. So not trying to say we didn't do a good job, or not trying to say that it's not important, but it's just, I just want to be accurate. And when somebody puts a building up for sale and they say they're going to sell it for $7 million and we buy it for $5 million, you could say we saved $2 million, but that initial price by a broker sometimes doesn't reflect the market. But so I'm happy with the building, happy with the savings, not complaining, just saying that for accuracy, we should be accurate. That's all I have.
All right, thank you, Commissioner Unruh, for those comments. Commissioner Ranzau.
Thank you, Mr. Chairman. I agree it's important to be accurate, so unfortunately I'm going to have to correct the factual inaccuracies in my colleague's footnote. We are not double counting anything. That savings that we're reporting does not include the tag office. We included the cost to renovate all 6 floors.
Including the tag.
All 6 floors.
Including the tag.
It's about renovating the building, because originally the tag office wasn't going to be in there, but then it was put in there. But then, fortunately, the majority of this commission realized that the plan put forth by the previous manager was going to be a parking and financial disaster. And we challenged that plan and corrected it and saved the taxpayer $10 million. Now, I know we could have saved even another $2 million more had we been more prudent in the decision to buy the building in the first place, because we still spent twice as much on the building as what we needed to if you talk to people in the real estate industry. But nevertheless, the savings is significant. Now, that's not a story that people want to get out, because the conservatives challenged the plan, and they made good decisions, and they did good things on the taxpayer, and that doesn't help promote political agendas, and so the media is not going to cover it. But I don't want to downplay it. It was a tremendous. This is what you have to do. You have to ask questions, and that tag office was another tremendous decision that we made, quite frankly, because it would have been everyone recognizes now, we put the tag office there in the it would have been a disaster. We have a fantastic tag office there, something that's been needed for decades. Both of these problems got solved in meaningful and cost-effective ways, and I think we should be celebrating that as opposed to hiding it. But I can't control what the media does, but nevertheless, this is a good story for our community, and let's celebrate it.
All right, thank you. Commissioner Peter John.
Well, thank you, Mr. Chairman. I'll just state for the record, yesterday afternoon we had a WAMPO meeting in the Reagan building, and there are approximately 75 parking spaces for the public that were available, and I got to the meeting a little bit late, and most of the spaces were occupied at that time. And I can't guarantee where all the cars were and where they came from. When I left that meeting, there were quite a few spaces available, and the 75 spaces that are out for the public, and I think there's 16 more that are on the south end of the building. We're struggling with the parking issues with that at the moment, and it's great that we have an agreement with the city where the city helps us and provides us with additional parking spaces east and northwest of the building too. But if we'd put the tag office in there, I think it would have been an utter disaster. And in fact, I was surprised yesterday. I received the first comment from anyone in the public. All the comments I've had about the tag office was, "Wow, that's a great facility. It's got plenty of parking." And I had somebody come up to me the first time and said, "Man, had a little trouble finding a place to park at the tag office last week." So I'm hopeful that we still have plenty of places at the new tag office. I'm absolutely delighted we didn't have them there. But if you want to take $2 million out of the $10 million in savings for what we ended up paying for that tag office at Meridian and Douglas, I'm not going to get into a big argument about it, but parking had been a big concern for me, and I am delighted that I think it's 140 parking spaces at that tag office, and I'm glad we've got each and every one of them. Thank you, Mr. Chairman.
Thank you. Commissioner Ranzau?
Yeah, there was one other detail about the Reagan building that I wanted just to get out there for the public, because you're probably not going to read or hear about it anywhere. The original plan was to gut the whole building, tear out all the walls. That was going to lead to significant reconstruction costs. This commission challenged staff to say, "Hey, let's see what we can do to make use of the existing rooms, the existing walls, the existing furniture, and try to minimize that amount." They were very successful in doing that, but we took heat for doing that. There was consternation. There were commissioners who didn't want to do that. That saved millions of dollars just by doing that. And Dr. Tom Stoll's they're very happy with the space and everything. They have space to grow and everything. It's working out tremendously. Additionally, we demonstrated the prudent use of bonding and using cash. We did bond the purchase price of the building, but we paid cash for a lot of it because we brought down the cost so significantly that we were able to do that and save millions of dollars on interest costs as well, which is important. I don't want to discount that. So there were a number of, this is really some of the issues that we have when you're in government. You only hear and read certain things, but there's always lots of details in some of these things, more so than what we ever hear. And if you just rubber stamp everything that comes by, then you lose these opportunities to save money. And I'm very proud of the efforts that we did. I hope, despite the political climate, that in the next couple of years we'll continue to be able to do these sorts of very common sense decision-making decisions to save taxpayer money that are very, very prudent. Thank you, Mr. Chairman.
Thank you, Commissioner Ranzau. Any other comments for other before we go on? All right, seeing none. Madam Clerk, next item, please.
Executive session.
Commissioner Ranzau.
Mr. Chairman, I move that the Board of County Commissioners recess into executive session for 25 minutes to consider personal matters of non-elected personnel, consultation with an attorney for this commission which would be deemed privileged in the attorney-client relationship, and that the Board of County Commissioners return to this room from executive session no sooner than 12:12, and that the executive session is required to protect the privacy interests of an identifiable individual and protect the county's financial interests and right to the confidentiality of its negotiating position.
I'd second that motion. Any discussion? Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh?
Aye.
Commissioner Norton?
Aye.
Commissioner Peterjohn?
Aye.
Commissioner Ranzau?
Aye.
Chairman Howell?
Aye. Thank you. We'll be in executive session until 12:12. Thank you. session. I'd like to call us back to order again, but no binding action was taken during the executive session. But we do have an item to discuss. I'd like to recognize Councilor Eric Yost.
Mr. Chairman, Eric Yost, County Councilor. We have an off-agenda item. I'd like the chair to recognize Mr. John Wolf, an attorney with Cripple Wolf Garrettson. He's been representing us on a matter. I think he's ready to propose to you a settlement.
Very good. Mr. Wolf?
Thank you. As you recall, the county filed a lawsuit against the general contractor and one of the subcontractors on the NASCAT Gateway building out north of Jabbar Airport. Some of the work was not done according to plans, which caused some infiltration of water into the building. The experts, as a result of the lawsuit, looked at it, determined what needed to be done to fix it. We had a mediation, and the defendants have agreed to pay $195,000 to the county, which will take care of the corrections that are needed to be done.
Well, very good. Thank you for the presentation, Mr. Wolf. Commissioners, are there any questions or comments? Commissioners, what's the will of the board?
Mr. Chairman, I'll move that we approve the proposed settlement.
Second.
We have a motion and a second. Any final discussion? All right. Seeing none, Madam Clerk, please call the vote.
Commissioner Unruh?
Aye.
Commissioner Norton? Mr. Peterjohn?
Aye.
Commissioner Ransaw?
Aye.
Chairman Howe?
Aye. All right. Thank you. Thank you, Mr. Wolf, for being here today. All right. That brings us to the end of the agenda. Commissioners, anything else before we adjourn today? Mr. Manager, anything?
No more.
Mr. Yost?
No more.
All right.
I'm satisfied. Thank you.
I think we've completed everything we have to do today, so we'll be adjourned. Thank you so much.
Are we still on at 1:30 though?
Production and broadcast costs for Sedgwick County Commission meetings have been underwritten by Sedgwick County.